I'm glad you can join me today for the video tip of the day. And I want to answer a question for you that clients often ask me: how long is the typical indictable criminal matter take in the court system from first appearance right through to the trial or jury trial, judge alone or jury? And I'll answer that question in the context of the Ontario Court of Justice, and also if you elect to the higher court. And I also want to refer you to a much more detailed video I have on this topic about the typical court process for indictable matters, more lengthy. But this one's going to focus, the one I'm doing now is going to focus more on just the timelines. So what's going to happen is you're going to be charged by the police, and they're going to give you a court date, 3, 4, 5, 6 weeks down the road in the Ontario Court of Justice. You're going to be then in the remand system, intake court in front of a justice of the peace. And what happens there is you're going to be in that remand court, depending on the case. Let's take a sexual assault case, for example, maybe 2, 3, 4 months, 5 months at the outside. At the end of that process, you're going to be expected to be in a position to want to set a trial date. The court's going to demand of that to you. And depending on the county, they're going to put pressure on even before 3, 4 months, for example. 3 months is typical, for example. You then set a judicial pretrial. You have that judicial pretrial. It's kind of a management function for court time, meeting with the judge and the Crown, and behind closed doors, the accused is not present for it. You're in a position then to set a trial date. If it's in the Ontario Court of Justice, that's what you've elected. It's going to be 4, 6, 8, 10, 12 months after that. So your case could be wrapped up, indictable offense, where you elect Ontario Court of Justice in as little as, I imagine the earliest possible would be 7 months. It's most counties, be a miracle to get it over in 7 months, and maybe up to 15 or so. If it moves beyond 18, you may be into a delay argument. So let's take another example where you've elected either judge alone or judge and jury in the Superior Court of Justice with a preliminary hearing. Going through the same process then, you're going to have the same timeline, except at the end of the judicial pretrial of the Ontario Court of Justice, you're going to set a preliminary hearing date, which again is going to be down the road 4, 6, 8, 10, 12 months max, maybe. After your committal for trial, once you've had the preliminary hearing, you're going to be likely committed to trial. Usually it's such a low test, you'll see in my other video, that it's going to go to trial. And then you move into the Superior Court of Justice. You go through the same remand process, but probably shorter. Maybe 1 or 2 remand appearances a month or 2 in. We're ready to set a judicial pretrial date. Once we've had that date, then we set either the jury trial or the judge alone trial. Maybe 4 would be way too low, but maybe some counties will get you a trial in 4 months, but we'll say 4 to 12 months down the road. So when you add up all those periods of time for a indictable matter where you elect a judge alone or judge and jury, it could be as much as 30 months of time where you've had a judge and jury trial or judge alone, or in most situations, though, less. Like I'm going to say, 18 months, 2.5 years, depending on the county. And one example of a county that's really burdened is Brampton. So there you have it. That's kind of the typical timeline. It varies across the province, and I just really want to thank you for joining me for the video tip of the day.